Hello, everybody, and welcome to the mini presentation slot session sponsored by Schweiger and Partners. The session is 7 golden rules for patenting software implemented inventions that protect you against failure. And the speaker is Martin Schweiger, Managing Director of Schweiger and Partners. So, Martin, you can take it forward from here.
Oh, nice. Okay. So today I'm talking about patenting computer implemented invention and software inventions, 7 golden rules that protect you against expensive failures. I have 11 slides and only 15 minutes, so it's going to be a tough ride. Right? On the left corner, you see my personal website, iplawyertools.com. Everything will be there and even more about that. I'm currently writing an article series about that, and I'm using that opportunity here just to clarify a few things in my thoughts so that I'm clearer with what I write. So first I give you an introduction, then the golden rule number 1, there is no prior art available when you need it most. Golden rule number 2, be clear about the motives for filing a software patent. There are several motives and I will explain to you what is good and what not. Golden rule number 3, CII patents involve a lot of painful work. Golden rule number 4, only genuine programmer technicians should draft CII patents. Golden rule number 5, many CIIs are selection inventions. Golden rule number 6, document how your CII patent application has been drafted with the end in mind. So, golden rule number 7, there is no artificial intelligence, AI, and there will never be one. These golden rules are interwoven in terms of risk of failure with your patent application and money and time spent. So, about the introduction first, let's define a software patent. Is what I understand as a computer implemented invention patent. When I started in the profession almost 30 years ago, then we only spoke about computer software patents or software patents, and today we call that CII patents. The gold standard for CIIs is, if you make it in the UK, then you make it anywhere in this world, right? Technical nature or technical contribution of a patentable invention is different from country to country. There's no silver bullet. To the contrary, the result cannot be predicted at all. In very short words, one and the same CII invention can be patented and not patented even by the same examiner, depending on how the patent application is drafted and worded. So let's explain the golden rule number 1. There is no prior art available when you need it most. And when you need it most is when you start drafting the patent application. And the problem is, once it's drafted, you cannot add subject matter to a patent application. So it sits there as you have filed it. That makes it extra difficult. When it comes to a patentability of a computer implemented invention, you will not be able to find useful prior art before you start drafting that patent application. Depending on the creativity, knowledge, and the grit of the patent examiner, you will learn a lot about new prior art documents during examination. And that is especially the case in common law jurisdictions that follow the UK. In my article series, you will learn more about that. The golden rule number 2 would be clear about the motives for filing a software patent. And I talk about the patent strategy point of view. Patents for computer implemented inventions can be helpful to promote negotiations for license fees. But a lot of effort has to be put in when you want to make these software patents work for obtaining an injunction. That's a real problem, right? Then the golden rule number 3, CII patents involve a lot of painful work, right? Especially when you have something here like the algorithm below. This is a complicated matrix formula, is an algorithm covariance matrix. And the problem is, describe the alleged invention in such details that it can be understood from the patent application itself without citing additional external sources. And you must describe why you think that it has tangible advantages, right? And what I mean with that is to understand a new algorithm, run it on paper with a small sample input. And this is taken from a book that I would like to recommend. It's a very small, short book. It's written by Gladstone Ferreira Filho, Computer Science Distilled, Learn the Art of Solving Computational Problems, issue 2019. And the example from below that I've given you is from the G119 or T1227 of 05, the Infineon decision recently just maybe less than 7 months or 8 months that this was issued by the Enlarged Board of Appeal of the European Patent Office. And you find a lot about that algorithm that is described below. Golden rule number 4. Only genuine programmer technicians should draft CII patents. And the reason for that is that for drafting your patent application, you should have a patent attorney on your team who has made a living as a programmer for an extended period of time before they became patent attorney. And just to give you an example from my own personal experience from my life, one of the first complicated algorithms that I've programmed was a pseudo-inverse algorithm that's used in robotics, and you need that algorithm if you want to control a robot arm with several links. I've put the URL here where you find the example that I found. There is no direct formula or algorithm for the pseudo-inverse of a matrix A other than the famous formula. And then you have this formula here is transposed, and you multiply and you do inverse and whatever. But the problem is this famous formula is computationally expensive, right? And below this person here described what would he suggest as an algorithm that is better, less expensive, right? What you need to do is you need to show what is computationally expensive. Use of a lot of memory, many steps, or whatsoever, right? And the problem that you need to solve in your patent application for this CI is you need to explain with that data why the invention is less computationally expensive. And when I say expensive, I do not mean monetarily expensive, but why it has this alleged advantage. And in order to do so, you must have worked as a programmer. I cannot possibly imagine how you can do that if you just as an abstract person with no tangible experience at all, try to start to draft a patent application. Golden rule number 5. Many CIIs are selection inventions, right? And for drafting and prosecuting your computer-implemented invention, you should have a patent attorney on your team who is an expert on so-called selection inventions. A metallurgist programmer patent attorney can be very helpful, or a pharmaceutical programmer patent attorney. I mean, these special areas of patent law, they are full with selection inventions, and it would help you to have such a guy on the team. A patent can not only properly be granted for an invention that is claimed as non-obvious, if the invention actually has the alleged effect. And that means you should describe that alleged effect in the patent application itself. Alleged advantages over the closest prior art without offering the support from the specification cannot be taken into consideration when you want to argue for inventive step. When you do so, you need to determine the problem which is underlying the invention, and therefore only then can you assess the inventive step or non-obviousness. And if you don't have that example in the patent application, then you cannot argue for that, at least not before the European Patent Office. Golden rule number 6. Document how your CII patent application has been drafted with the end in mind. And for drafting and prosecuting your computer-implemented invention, you should have a patent attorney on your team who has at least 3 successful patent litigation under his belt, better more. And I tell you this because I see the same rookie mistakes over and over again, right? For example, someone claims the entire system that does something instead of its components. And the problem is, today with the internet, the components of the system can be located in different jurisdictions. And then you immediately are in discussing contributory infringement instead of literal infringement. So by claiming the system instead of its components, you're immediately in a very, very difficult legal situation. Next one, claiming a method that of which parts are performed at different places at different times. Same problem, right? You have a patent claim for a method, and let's say the first method steps are performed in 2020, and the second half of the method steps are performed in 2021. Then how do you want to collect evidence for the infringement? And all that can be avoided if you have at least someone on the team who thinks about the patent from a litigation point of view. Then, golden rule number 7. There is no artificial intelligence and there never will be one. And what I want to say in very short words, don't fall for buzzwords and for people who use them without the proper attitude. Right? Proper attitude, I want to say, I mean, artificial intelligence is if you say something like, I have solved my problem with artificial intelligence, to me it sounds a bit like, I have solved my problem with thinking. Such general, I would say. So artificial intelligence is always very specific, but it will never be the religious artificial intelligence that would be more powerful than a human brain. We have for thousands of years not understood how our intelligence works, but there are people out there who dream of artificial intelligence without being able to word what is the human intelligence. And one more thing, if there is AI, it will not be patentable because it cannot be described in an enabling way in a patent application, at least not as I think. And although patent law could theoretically be extended in order to allow machines to be named as inventors, that will only happen after animals are allowed to be named as inventors, and I don't think that this will happen. I give you here a short link where you can find more about that. I come from a theological point of view, and that explains why I'm so harsh here about that aspect. So there's not much leeway for discussing that. Now I'm almost at the end of my talk, 3 minutes left. Now I just want to, instead of thank you for listening, I want to just reiterate what was the contribution of my talk here. Drafting CII patents cannot be cheap, right? It is all about dealing with uncertainty. And for that, you need experience. Drafting CII patents is not only about experience, it also requires creativity. And when I say creativity, I mean 10% inspiration and 90% transpiration. A lot of work has to be done in order to get a good CII patent that has a good chance of being granted. Drafting CII patents requires sober minds and not crackpots who dream about making computers more powerful than humans. I just wanted to add something on. Sign up for the free tip of the week in my personal website, iplawyertools.com, because you find a lot of stuff about computer software patents and CII patents. It's very simple. You can do it now on your smartphone or the computer, either on the top right side of the screen or at the bottom when you scroll down from your smartphone. There would be this tip of the week followed by sign up for your email address, and then you need to accept the privacy and cookies policy, and then you click sign me up for free and check your email inbox because I check whether you're really the one who signed up for the tip of the week, and I need your confirmation for that. So I'm now at the end of my talk, and we can switch to the question and answer session. Thank you.
Yes, Martin, thank you so much for your presentation over here. It was a brilliant one. I was quite interested in it on my own itself. Not being from the software, department or from the law department.
Okay.
So it was still very interesting. So before we move ahead, I would like to ask the participants if anyone has any questions to be asked from Martin regarding the interesting presentation that he just presented. So you can just write it down in the chat box or in the Q&A tab on the right side itself. We do have a question from Gerard. It says, do you always include a method claim for software patents?
Yes.
So I hope, Gerard, do you have got your answer, or Martin, would you like to expand on it?
I mean, when you do a software patent, that very often the device itself can only be described with the features of the computer plus some functional features. And the functional features always are a problem in litigation and also during prosecution with the prior art and so on and so on. And the method steps, they can be very, very, very specific to a degree that the examiner runs out of prior art. And that gives you the advantage over the prior art, because you always take up another method step and another method step in order to achieve novelty. Then it boils down to inventive step, and now you need all the experience in order to make that. And the question is, once you convince the examiner about the patentability of your method, then it's easier to find a device claim that can be patented, because only then the examiner has understood the invention. Very often from the device claims, examiners don't understand the invention at all. So that's another reason why you should have the proper method claims in your patent application.
So Gerard has another question, but will it be difficult to enforce?
I mean, the enforcing software patents is always a pain in the neck. But the good thing is, in order to defend yourself against an infringement claim of a software patent is also difficult. So very often what I see is that litigations about software patents end up in a gridlock, and then they would be settled at some point in time. So if I can choose a mechanical patent and a software patent for litigation, I would always go for the mechanical patent.
So I hope, Gerard, you've got your answer from Martin. And we also have a question from Susmita. Which type of claims carry more weight, method claims or apparatus claims?
Of course, the apparatus claims, damage-wise, because if something is tangible, then you can more easily identify a price. And then damage calculations is better. Also, if you have an apparatus with features, then it's more easier to find out whether this infringes or not. And especially when we talk about method claims or means plus function claims, the pure apparatus claims are much more powerful in every aspect of the game, I would say.
Thank you, Martin. I hope, Sushmita, you've got your answer. So thank you very much, Martin, for coming for this conference and joining us for this presentation.